Good morning, Your Honors. May it please the Court, I'm Bill Gressley from here in Jacksonville. On behalf of the appellant, Mike Wood, I'd like to reserve 3 minutes for rebuttal, and if I run through the form, we won't have that much left. I said it privately, but I want to make sure I said it to each of you. Thank you on behalf of all of the Jacksonville lawyers for sitting here. This is a huge benefit to us, and it's also a huge financial benefit to our clients. The issue presented here, there's actually several of them. This is an appeal from an amended order on former husband's supplemental petition for modification of final judgment of dissolution of marriage, and former wife's third motion for contempt and enforcement, which was entered a year ago, approximately 5 months after a trial of this cause. The appellee's predictable and understandable response to every argument I've made is, of course, it's within the trial court's discretion, and as well as fact-finding and findings of credibility, none of which we submit to withstand scrutiny. There are 3 distinct issues that I've raised here. One is the amount of the reduction. And I'm going to talk about the contradictions within the order under review because I think they're important to point out what's really at issue here and what needs to be done.
So it was reduced from $5,000 to $4,000?
Well, it's $3,500 and $500 arrearage for a period of a year. So the second issue is the temporary versus permanent nature of this, and subsumed within that is the failure of the trial court to provide any retroactive relief to my client. And then finally is the contempt issue, which follows concomitantly from the findings that the trial judge made. I think the real starting point for this is the initial consent final judgment, and ordinarily it would not have been an issue because there appears to be an explicit recognition by the trial court that there has been a material reduction of income. I'm going to talk about the temporary and permanent nature of that in a minute, but the important part of this was a finding that the trial court made in passing gratuitously in paragraph L of the order under review that the initial financial affidavit of my client showed a $4,000 some odd a month deficit, and if that was true, then how could he possibly have consented to paying the former wife $5,000 a month? Well, there's a couple of answers to that, and one of them I'm reminded of an argument that was held at the prior location of this court some years ago, and I think Mr. Korn and I were on each opposite sides, and Judge Webster made a comment that in all the years he sat on the circuit bench, he maybe saw 2 accurate financial affidavits in family law case the whole time. And I think that one of the problems is not only the natural tendency to put the figures in your best light for your client, but the real problem is taking a snapshot at a particular point in time when, by definition, the marriage is getting ready to fall apart and everything's going to change. I went over last night because it finally struck me that may have some significance to the measurement of the change in circumstances. And on the initial final judgment, which again was entered into by consent, the financial affidavit of my client had approximately $2,000 a month in expenses for the marital home, which the testimony below in this hearing was that the parties had separated a couple of years before the dissolution was entered. So there's a couple of $1,000 in expenses for the marital home that were no longer going to be incurred because they agreed to sell it.
Counsel, before we get too far in the weeds, I mean, I read that paragraph in the context of your argument that the trial court should not have given any more significance to a consented amount than another amount.
Right.
But I ultimately read that paragraph the way you're describing it today, that the trial court is articulating essentially that I just don't believe the numbers I'm getting from the former husband.
Well, and I think that it's odd and unanswerable and inappropriate for a trial judge, 2007, 4 years after the fact, to start making comments about the credibility of a financial affidavit that was entered in a consent proceeding in 2007. But my point, I don't want to get in the weeds either, because that's where we get lost on what the actual issues are here. The point is there's over $6,000 of expenses in my client's initial financial affidavit that the parties knew at the time they consented to the $5,000 a month would not be continued to be reoccurred. They sold the home. The child that was living at home was no longer there. He was not paying the college expenses of the child.
Was that all explained to the trial judge in the order on appeal?
No, because this was a gratuitous comment made by the trial judge. And the important part of that paragraph, and what's important for purposes of this proceeding, is that at the time that this consent was entered into for the $5,000 a month, my client was grossing over $15,000 a month in income. And the whole premise for the supplemental petition, which is what has gotten us here today, is the fact that my client has lost over half of his income. Beginning in 2008 and 2009, he lost 4 of what he called, in his testimony, his top 10 clients, which resulted, it was Watson Realty, and I've got them listed somewhere in my notes. Watson Realty.
His supervisor or employer testified, and that was not rebutted.
No, and there's 2 components of my client's loss of income. Before we get to Mr. Perry, the employer, he lost 4 big clients because of the economy, and one of them was because of a merger and the employee benefits.
My point was, there was no contest or dispute as to a loss of income. The question is how much.
Exactly, and there was also, as I reread the briefs and reread the testimony, and in preparation for today, the real issue was, well, he still has the ability to claim certain business expenses as debts, and he spends money going to Whole Foods to eat takeout food.
Or to the wedding, whatever it was.
They both took a trip to see their daughter's brand new baby. Yes, they both did that. But my point is that the uncontradicted testimony from both my client and Mr.
Perry, $6,000
when he was making $15,000 a month, and the appellee had gone off to have her own relationship with another person. Even assuming all of that's true, the real important part is
that was not rebutted.
It was. My client explained it, but it was. I say it's not relevant, and the important part is the bigger picture. The 4 clients that my client.
This need ability to pay.
It is, but the component that is huge compared to what are very de minimis amounts that happened back when my client was making almost $16,000 a month is the loss of 50% of his income. First, from the loss of his 4 of his top 10 clients, and then right before, after the first financial affidavit and before the trial, and this is what Mr. Perry, the employer, testified to, is that he took what has been historically 30% of my client's income, which is the employee benefits book of business, and gave it to another producer in the office. That was permanently removed from my client's income. So by the time and the judge recognizes, the order under review recognizes that his draw had gone from $1,500 a month when he filed the supplemental petition to $880 a month before the trial. And then the judge just simply ignores that in terms of her analysis as to what a month. Yes, an $880 a month draw at the 6524 was his financial affidavit as to his gross income at the time, at the month before trial, $39,1868 net.
Well, it appears that there was some evidence put on by the former wife showing some sizable deposits into the former husband's accounts. That it appears that the trial court found that evidence more credible than what the former husband had put in his financial affidavits.
All of the bank accounts were in evidence. There were two things that I can respond to. One is some of those were double counted. My client had some pre-existing, before his current employment, income that went into a Jacksonville bank account and then went into his mercantile bank account, which was his business account. Both of those account documents were used as evidence, and there was testimony. Some of those were counted as 2 different sources of income. The important part is the trial judge says, well, there's $10,000. I'm going to find that there's $10,000 a month in income. The only way she does that is to ignore her own prior finding that there was $888 draw, and ignore the fact that Mr. Perry's testimony was uncontradicted, that the employee's book of business, which was 30% of my client's income, had been permanently removed from Mr. Wood.
But if I understood, remembering this incorrectly, the basis on her decision to make it a year versus permanent was that change that was made, he removed the book of business, but he was building a different book of business. Am I misremembering the testimony?
You're half remembering. You're correct that the trial court at least gave some recognition to the fact that he's removing, he's only receiving $888 a month now in his draw. What she doesn't do is then follow up from that and make any determination, and there's no evidence in the record from which you could find that there is going to be replacement income. The appellee makes this great argument that, well, he's going to replace this with business. Well, given the economy, which Mr. Perry and my client both testified to, and the lack of employers purchasing employee benefit packages, there is no evidence in this record whatsoever that can support a finding other than this is a permanent change in my client's circumstances. The actual evidence, even if you use the $10,000 a month, which we submit is completely improper, because what you're doing is you're averaging past year's income, which encompass and reflect financial circumstances that no longer exist. The trial judge had unequivocal, unrefuted evidence that my client's income had been reduced to a gross of $6,524, $3,900 net. His expenses are more than that. How can he pay $5,000 a month? And the trial judge does, in trying to be Solomon-like, and I say that not disparagingly, but as an appellate counsel who says you cannot speculate as to what the future is going to hold. And the Perez case, which I've cited in the initial brief, and I've repeated it in the reply brief, and the Wolf case out of the Fourth, and the Haas case, all point out that when there has been a when there has been a reduction that lasts some period of time, and in that case it was a year, in both of those cases, the Haas case and the Wolf case, and the third case, the Perez case, there had been some evidence that income was increasing at the time of trial, and the DCA said no. That the evidence was that this permanency that was met, the test of permanency was met, when there was a reduction that lasted for a period of time and there was no end in sight. Judges are not authorized to speculate about the future. My client testified as to what his actual reality was. Everything he had been doing for the last 15 years had now been lost. Most of his employee benefits from before were being reduced. He had lost 30% of his income from that. Mr. Perry was unequivocal that he had taken another 30% of my client's income with the transfer to another producer within his office. So we submit that if you're going to, even accepting, and it's wrong, but if you accept the $3,500 a month reduction as somehow justifiable, which doesn't leave my client any money to live on, but if you take that as justifiable, you can't say that there's going to be some miraculous change because in January, 2 months from now, all of a sudden he's going to have the ability to pay $5,000 again. There's no evidence in the record to support anything even remotely close to that. And that goes to my next to last argument, which is the finding that it should not be retroactive. Once this court recognizes that there has been a permanent and material...
discretionary?
I think it's an abuse of discretion standard that's subject to the same need versus ability to pay. And so once this court reverses and says, Judge, you've got to recalculate this using his actual income at the time of trial, and you also have to account for his own right to live.
And that's the relief you're requesting.
Yes, and you need to look. When he filed this petition in 2009, he had lost the 40%. His 4 big clients. By the time trial came about, he had lost an additional 30% because the employee benefits book of business had been transferred. And so the judge needs to do an analysis of his ability to pay at each step of the way during this proceeding because he is entitled to retroactive relief because he had no ability to pay at the time, that amount at the time of the supplemental
Income
petition.
be imputed to the opposing party?
At least minimum wage. And that was the whole point of this, is that she worked until, coincidentally, the supplemental petition was filed. Even forgetting everything else, the exceptions to the statute on imputation for staying at home and providing full-time care for a child, none of those apply. She should have had at least minimum wage applied to her. And the finding of contempt, Your Honor, I pointed this out as a tautology. It's continued to be used throughout the course of these proceedings. At all times, he had the ability to pay this $5,000 a month, so he's been held in contempt again. He does not. This record reflects he does not have that ability, and there's no basis on which the most current finding of contempt can be raised. And I would like to point out before I said that each three of the contempt orders entered by the trial court below set a different purge amount. And just like she recognized that he was implicitly recognized that he was reducing, had reduction in income, the purge amount kept reducing as well. The analysis needs to be, did he really have the ability to pay? You cannot simply repeat the trial counsel's incantation that at all times majority he had the ability to pay this amount, when in fact the record shows that he did not. I've got a whole minute and 13 seconds left. Thank you.
May it please the court, I'm Michael Korn of Korn & Ziemer. Please represent the appellee, Candace Wood, in this case. Counsel is asking this court, under the guise of purported de novo review, as he says in his brief, to basically reweigh the facts and substitute judgment for that of the trial court. There were 3 issues presented on the brief. The main argument, of course, dealing with whether, in fact, there was a substantial change in circumstances. Trial judges in this economy are dealing with variables that perhaps have not been seen in decades. They're dealing with scenarios where some level of discretion, some level of creativity, if you will, needs to be applied. And that's what this trial judge did in this case. Counsel, and I'll go backwards a little bit, because counsel treats the contempt issues as almost a side thing. Goes, oh, just we won't worry about that. That just proves my case. Well, what was intriguing about this was when he filed his original petition in October of 2009, his big loss of income hadn't really occurred yet. But he writes her a letter with the check for $1,000. Says, my lawyer says this is what I can pay right now. So he basically decided, I'm going to start my own little self-help remedy. So he cut her to $1,000. Then some months didn't pay at all. Then some months he pays $1,000. That led to not 1, not 2, but ultimately 3 orders on contempt. Now, I learned back in law school that one of the principles is you can't defy an order that at the same time you're seeking to either have relief from or some kind of change to. And what we've got here, quite frankly, is not the same type of dire financial circumstance that counsel raises in his brief. Judge Swanson, you asked about retroactivity a moment ago, and I think that there's a significant issue that we can talk about. The trial court, as I said, I think made a sensitive discernment of what was going on here. The most important thing she figured out is she just didn't believe him. What she believed was the income that he was showing on his federal income tax returns, separate from the liens.
That's why I asked the question about the testimony of the employer. That was unrebutted with the employer testimony.
Your Honor, but this is the point I'm getting to, and it goes to this whole retroactivity thing. If anything, if there was any real change in this man's financial circumstances, it occurred, if at all, in July of 2010 when this book of business was transferred. Now, what was also significant about Mr. Perry's...
Are you suggesting there was a track record of disregarding the order of the court that preceded the loss of income?
Flagrant one, Your Honor. I mean, this wasn't just a one-time thing. This was a third contempt issue. And what's intriguing about that is, he continued to basically meet the other expenses. He paid adult children's expenses. It's a matter of choices.
He was paying a student loan, as I recall.
A student loan, he paid some minor stuff, and I don't mean to make it minor, but it's, I think, indicative of an attitude, which was, if I take a hit, the wife needs to share 100%, but these others aren't going to. That's not what the law provides on a modification. So to your point about retroactivity, to the extent that there was any change, potentially, the judge, I think, very sensitively said, look, I'm going to give it a year and see how you do, because you may have lost the employee benefits portfolio, but you're increasing your life insurance, you're increasing your estate planning portfolios. Let's see how you do. It's also significant, and the testimony here was also unrebutted, that Mr. Wood said during the recession of the late 80s, he lost 25% of his income. Guess what happened? He worked, he built it back to the incomes that he was at the time of the dissolution back in the mid-2000s. So this issue of there's no end in sight, and that's a phrase we hear in the briefs, we've heard again this morning, no end in sight, I think is not really what occurred here. What no end in sight was the husband just basically making the decision he wasn't going to pay this, and he was going to take whatever steps he thought were appropriate to avoid himself. The trial judge made a specific, I can't make it any more specific finding, where she says, I don't believe the data in his financial affidavit, said it explicitly. And so what do we have here? We have data that in 2007, from his federal income tax reported income was about $186,000. And it went down in 2009 to about $153,000. So he, at best, a $30,000 hit on what is not a huge alimony award given a 30-plus year marriage, and a wife who literally left the marriage with almost nothing. Counsel alluded to the sale of the house. What he didn't tell you was the other part.
There was a tax lien.
A huge tax lien.
Most of that.
Yes, sir. The tax lien, by the way, remains unpaid. He made one payment to the Internal Revenue Service post-final judgment. And the irony of that, the sad irony, unfortunately, is not only does that lien remain unpaid, but when the wife got a small refund from some of the incidental work that she had been doing, it was seized by the IRS because although the final judgment said husband's responsible for the lien, that's why she gave up her interest in the marital home. The IRS said, hey, your name's on this too, we're going to take that. And so we have a scenario where she chooses not to pay the alimony, he chooses not to pay the IRS, yet he puts it on his financial affidavit as a $1,500 monthly obligation. Doesn't pay it, not paying it. And that's why this trial judge, evaluating all the facts, says, I don't believe the data. And so to the point, if there's anything, the judge said, I'm going to give you a year. Let's see how this new adjustment of the portfolio works. Let's see how you do in reestablishing your business.
Is that within the discretion of the court to do something of that nature?
Absolutely. And in fact, this court, in a case McQuaid, which Judge Marsteller authored, basically acknowledged that you can have temporary reductions, and let's wait and see how it works out. And that's why I started my comments, Your Honor, with an observation that in light of the economic circumstances that we are in, the trial judges have to be given that type of broad chancellor-like discretion. There's been no showing that there's been any abuse of that discretion in this case.
If I understand his argument, is the abuse of discretion came in when the trial court used the $10,000 figure, which came about a period about 6 months surrounding the filing of the petition, a few months before, a few months after, that the circumstances then are entirely different than the circumstances that were proven at trial, financial circumstances. Am I at least understanding his argument correctly?
I'm not sure exactly what his argument is, Judge. It's kind of let's take this shot, let's take that shot. And our brief, and you'll see at page 8 and 9 of the brief, lays out month by month by month what the receipts were. He claims double counting. He shows no proof of it. There's no citation to the record of double counting. That is an absolute red herring. What can we believe? We can believe, we think, that in 2009 he earned $153,000. That's what he told the Internal Revenue Service when he filed his tax return. While lower than it was at the time of the final judgment, is it material enough to warrant the type of permanent change that would be required in a modification? We suggest no, and we suggest the trial court appropriately exercise her discretion in finding it not to be the case. Now, what was also interesting, he had always been on a 1099 basis. It was only until 2007 that Mr. Perry at the insurance agency put him on a regular W-2 status.
Let me ask it a different way. If someone files a petition for modification based upon their circumstances at the time the petition is filed, and those circumstances would not be enough to warrant a change, a modification of any kind. Time passes, it takes a while to get on the court docket, and by the time we go to trial on the issue, there has been a significant change. Would it be an abuse of discretion for the court to say, I don't believe anything you told me, even though it was unrebutted? Whether this is this case, I'm not sure. But in any event, I don't believe anything you told me there, so I'm going to use the information that was presented when you filed your petition.
Well, I think the court can do that, but the court didn't do that in this case. I mean, that's a hypothetical that I don't believe is the facts of this case, and that goes to this issue of retroactivity, which, ironically, I think, although I don't think the appellant meant it that way, I think it actually establishes why there's no abuse of discretion, is because the happenstance timing of Mr. Perry's decision to reallocate the portfolios within the agency occurs the month before trial. That may have been, in fact, the one area where, and Your Honor said he was unrebutted, how am I going to rebut Perry when he says, yeah, that's what I did. He did what he did.
There are other ways. I mean, you had discovery was available.
Right.
You had the ability to subpoena records.
But the issue, but what I'm saying is I think it's a false issue in the sense that if, in fact, that portfolio...
Well, that may be, but the ability to rebut testimony is available to you.
Always, of course. But this is the point. When Perry was specifically asked, well, tell us, Mr. Perry, how much is this really going to mean as far as Mr. Wood's income? Don't know. He couldn't quantify it. He couldn't tell us how much he was going to pay the new person in his shop that was going to be taking over this portfolio. So it was highly speculative as to what exactly the impact of this portfolio adjustment was going to be. And so hopefully coming back to your question, Judge Weatherall, we don't believe that he made his burden when he filed in October of 2009. As it turns out, events kind of overtook him, and he got enough evidentiary basis to show that there had been a change, not a permanent change, arguable whether it's substantial, but the judge says, I'm going to go ahead and cut you from $500 to $3,500 with the $500 that you're supposed to be paying on this purge. A point on the purge, counsel argues and said that,
Well, before you get there,
Yes.
I guess what I'm still confused about is the judge made specific findings that if his gross income was $10,000, that was based upon the numbers in and around the time the petition was filed, rather than any evidence that was presented.
But, Your Honor, there was no other income information that was presented, because at the time of trial, and again, the numbers are laid out in the brief. You can look at them at pages 8 and 9 of the brief, and they lay out all the way through July of 2010. The change, if you will, that no one could quantify was this change relating to the realignment of the portfolios. And he didn't present any testimony of that either, Judge. It wasn't like he came in and said, well, here's what I've lost from Company X, here's the group benefits from Company Y, here's the benefit package from Company Z. None of that was ever presented. It's his burden at all times to prove up a substantial material change in circumstances. Didn't make those numbers.
So where's the $6,500 gross, $3,900 net number that we've heard about this morning coming from?
That's coming from his testimony, and it's coming from partially financial affidavits that the court discounted. I think the better approach, and we cite with Garte, it's a rather familiar case, which talks about that, especially in scenarios where folks are employed by themselves or have a small business, and this guy really kind of was, because he was getting income beyond just the J.P. Perry income. He had some side income, which Mr. Perry knew about. It was not a problem for him, but he had an independent producer's license, which allowed him to obtain some additional side income, and that's also laid out, and those numbers are laid out in the brief as well.
Let me just ask a question, real brief. The hearing was held in August of 2010.
Yes, sir.
When's the year run?
The year runs, I believe it runs to the date of the judgment.
And what was the day of the judgment?
Well, there were two judgments. There was original judgment.
The amended final.
Amendment final was filed December 13, 2010. So you've got, what, a month plus. That's correct. Yeah, the only reason for the amended judgment was there was some clarification on the exact dates that he was supposed to make certain payments, but no changes to the merits of any of the rulings. But to the point about the purge and the retroactivity, again, I think we've shown why retroactivity is a red herring, because there was nothing to be retroactive about. The change, if at all, that Judge McCallum was trying to deal with and be sensitive to had just occurred, so there's no justification for retroactivity, therefore no discretionary abuse. As to the purge, we can sit here and argue about whether he should have paid the full amount that he had obligated himself to pay beginning in October of 2009, but he didn't. And now he's got a $38,000 amount. Now we can either put him in jail, or you can give him a purge amount with a schedule that makes sense. The fact that he makes recurring income month to month doesn't mean he can then pay a $38,000 purge. They're two different things, a recurring income versus a pot of money that you can pay from. So the comment about the purge number went down, that therefore somehow benefits him, I find kind of interesting, because in essence, Mr. Wood was being given the benefit of his contempt. He continued to be contemptuous of the court's rulings, not just the judgment, but the first and the second order of contempt, and yet he's able to proceed on without an effective method of settling. For these reasons, we would suggest there is no abuse of discretion in this case. The Perez case that he cites, I'll just point out quickly, is distinguishable on a couple of grounds. First, there the judge not only didn't believe Mr. Perez granted a directed verdict at the end of the case. The court said, well, wait a minute, we're not going to go that far. But more significantly, Perez was in a direct mail marketing business that all of the experts said was basically a dying breed. It was a horse and buggy industry. The insurance business is not going away. Mr. Wood has shown his ability to be resilient. He will be resilient again. That's what the trial judge is betting on. If he doesn't, he's got a burden to show in a month plus to see where he goes. For these reasons, this court ought not to substitute its judgment or reweigh the evidence. The court should also favorably consider and grant the motion for appellate attorney's fees, which the wife has filed concurrent with this case. For these reasons, we suggest respectfully that you affirm in its entirety. Thank you, Your Honors. I'm sorry. I have a minute and 13 seconds.
give you a full 2 minutes.
Thank you, Your Honor. The claim that there was no proof of any material change in circumstances until right before trial is absolutely incorrect and unsupported by the record. Page 6 of my brief, I quote, these losses these are the 2009 losses. These are the four of the top 10 clients that my client lost, which he testified is why he filed the supplemental petition. It constituted a 60% reduction in his health care book of business, a loss of $7,500 per month in income, which is gross income, 1/2 of his total income from the time of the consent final judgment. So there was a material change, and that's why the retroactivity issue is a real and important issue to be addressed. What happened on top of that was that Mr. Perry then moved the book of employee benefits business that was being managed by the Perry firm, and he gave it to someone else in his office. Mr. Wood had no input in that decision. Mr. Perry said, that's a permanent change. I'm not changing it back because this other person is on the cutting edge of everything that has to do with that. He said, I am going to put Mr. Wood in the estate planning and financial planning divisions, which he was in 8 or 9 years ago. There is absolutely not one scintilla of evidence that my client had been able to replace any of his lost income with any of that business.
Your client's 58 years of age.
That's correct, Your Honor. He is now. I think he was 57 at the time of trial. The truth is that my client paid the $5,000 a month current until he filed a supplemental petition. He filed his supplemental petition because he doesn't have any money. He did not pay the IRS lien. He did not pay his credit cards. He has not paid the full amount of alimony except once the judge said you're going to jail if you don't pay X dollars, which he kept decreasing. The idea of giving circuit judges creativity to deal with difficult issues, I'm fine with that. But where in the law, what principled basis do we use in establishing what the law is going to be for those of us who are in the pits here to say that, oh, there's no end in sight to your financial decline, but I'm just going to give you a temporary break and then make you come back and go through another modification proceeding to convince me that you really don't have the money that you've already proven you don't have. Forget the Perez case and its anomaly of a magazine solicitation business or whatever Mr. Korn says. The Wolf case out of the 4th, which cites to the Haas case out of the 4th, says that since the condition has lasted over a year at the time of the final hearing with no apparent end in sight, it should be deemed sufficiently permanent. There is no end in sight to my client's downturn. Unfortunately, we would all love to have it.
Let's close on that, counsel. Thank you. All right.
Thank you, Your Honors.
We are finished with our docket for the day.